Welcome to this half-day conference on the path to healing, America's International Covenant on Civil and Political Rights. I am your moderator and a presenter, Dr. Zena Crenshaw Logel. Our gathering was arranged by National Judicial Conduct and Disability Law Project, Inc., which you may know as the Law Project. I am a co-founder and an executive committee member, as well as executive director of the Law Project. Since 2005, the Law Project has been a nonprofit good government advocate focused on the U.S. legal system. The community organizing and mobilizing part of that work was dramatically reduced just a few months ago so the organization can refocus as a think tank and public policy analyst. Opt-in USA is a campaign that spotlights some of the Law Project's most important work as a think tank and public policy analyst. So on behalf of the Law Project, its board of directors, Opt-in USA, my fellow volunteer staff and board members, I'm sending warm greetings around the world because this conference is part of the Global Week of Action spearheaded by the UN Sustainable Development Goals Action Campaign and the People's Assembly. Here's what we have planned. First I'm going to bring you much like a State of the Union report by highlighting the key parts of annual reports that the Law Project has been publishing for Opt-in USA since 2016. As you may have gathered from promotions of the conference, Opt-in USA is an international U.S. foreign policy reform, judicial accountability, and human rights campaign. The foundation of most of what we'll consider today is a human rights treaty known as the International Covenant on Civil and Political Rights, which the United States of America ratified in 1992 with certain reservations, understandings, and declarations. RUDs are what we call them. So my colleague, Dr. Retta Daniels Alcaraz, will give us a brief description of the Iccpr and America's RUDs. And when she's done, and that'll be brief, I'll come in and briefly describe the first optional protocol to the Iccpr, let everybody know what that is. And also I'll be describing the UN General Assembly Resolution 60/147. It's titled Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross violations of international human rights law and serious violations of international humanitarian law. Now, contrary to what you may think now, this is not a conference. This conference is not like, a happy hour for brainiacs. You don't care if you have a GED, a PhD, a MD, JD, a CD, we are here as humans with human rights. Dr. Daniel Alcaraz and I hope to help all of us get a general sense of the extent to which our human rights as Americans are protected, not just in theory, in actuality, as a practical matter. But explaining what many, if not most of us, are all of us already know. It really wouldn't be much of a point for us gathering just to, hear what we already know, what most of us already know. That it might be fairly considered a waste of time. So what I'd like all of us to do to try to, move against the inclination to think we've heard it all before, because this is probably going to be a pretty sophisticated audience. We certainly have a stellar panel. But I'd like for all of you, if you will, to join me You're off screen, but just join me in a few seconds, and we're going to do a little deep breathing. All you have to do is just follow my lead, and we're going to inhale and exhale 3 times. And then I want you all to say to yourself, you can keep your microphones muted, and I'm going to say it as well. We're going to just say out loud, I am going to learn something new and important at this conference today. So, okay, here we go. I am going to learn something new and important at this conference today. Thank you, everyone. None of us, not even our presenters, not even me, should be here intending only to teach, only to talk. We are here to talk and listen. We're here to teach and learn. Now, Dr. Daniel Alcaraz and I will share information that some of you may not know. Some of you may know it. But if any of you have questions about it, please put them in the Q&A section we have here on Zoom. If you're part of our live audience, we want you to put your questions, your specific questions, in the Q&A section. And then if you have any information that you want to share, if something a presenter says is inaccurate or it's incomplete, or you have something that you want to add, our comment on what you're hearing today, or just some information that you think is helpful for the panelists and the audience to know, please indicate that. Add that to our chat section. If you're looking, we're live streaming now on Facebook. So if you're joining us through Facebook, you're not in our live audience. Just if you have a comment or question, just put it in the Facebook comment section, and we'll try to get to your comments and questions right along with our live audience. Now, at the halfway mark of our conference, there will be a roundtable discussion as an addition of the Turning Point Dialogue series of the UN Global Week to Act for SDGs, and that's the Sustainable Development Goals. So this Global Week to Act for SDGs, our roundtable presentation is part of that, and it's considered a turning point deep dive discussion. That's what the UN is considering our contribution to its Global Week to Act. And we have, right now we're expecting 9 distinguished panelists. Some of them have gathered, they're here early on. Some of them will join us a little later, just before the roundtable discussion, but they're all the distinguished panels. All of the panelists are distinguished, and I will personally welcome all of them just before their presentation begins. Each of our panelists will share in one way or another whether they think America's Iccpr, and again, that's the International Covenant on Civil and Political Rights. So our panelists are going to share from their perspective whether they think the Iccpr is the pathway to healing for those of us enduring persecution imposed through organized U.S. legal system abuse facilitated by unchecked judicial misconduct. So, ladies and gentlemen, we are here to turn it around for people against whom the U.S. legal system has been weaponized. The UN campaign for the SDGs actions as encouraging us to come together and turn it around, and that's the target of our discussion. People against whom the U.S. legal system has been weaponized. So I hope you came here ready to help us turn it around. So thank you for joining me, and just sit back and relax. And the day should go quickly. Our half day conference should go quickly. Now I'm going to move into my substantive presentation. So let me change my virtual background. Okay, there you go. I'm going to be tracking us through Opt-in USA's annual reports that the Law Project has been publishing, as I indicated, since 2016. In 2016, Opt-in USA told the world about America's shell game through its annual report that's titled Americans in Jeopardy. And the subtitle is when human rights protection becomes America's executive, legislative, and judicial branch shell game. So that came on the scene, and I think it was February of 2016. First let me emphasize that, again, this report is dated exactly February 16, 2016. And it quotes a 2010 document that's titled Joint Stakeholders Universal Periodic Review Submission, U.S. of America, November of 2010. And I'll share a link to all of the reports if you haven't had a chance to see them. We'll share them at some point during our conference. So again, we're 2016. That's actually Opt-in USA's debut report, and we're quoting a document from 2010, and it's referencing this Universal Periodic Review submission. And I don't know if any of you know about how that works. This review that we're referencing is of America's human rights record, which is conducted periodically by the United Nations. All nations that are members of the United Nations, periodically, they allow their human rights records to be pretty extensively reviewed. And then civil society, organizations, individuals, we are the stakeholders, and we're allowed to make a submission, and we share our views about the human rights records of the country that was under review. And so 2010, I think it happens like every 5 years, if I'm not mistaken. In 2010, the United States of America was up for this universal periodic review. Now, in this 2010 submission are these words that I'm going to read. It's just one sentence. I'm going to read to you verbatim. It says, the capacity of average Americans, well, now I'm quoting, the capacity of average, and then I'm quoting, Americans to effectively petition their government is so diluted or compromised that what would otherwise be our constitutional and universal human rights are no more than privileges doled out at government discretion. Now, 2010, joint stakeholders made that statement to the United Nations as part of its periodic review of the U.S. human rights record. And, I'm wondering if it's resonating. We're saying, and this was not just a group of, as my colleague, Dr. Jackson, who co-founded the Law Project with me, along with my late husband, this was not a group of barroom ranters. This was a very stellar coalition of activists, and it included some of our most productive grassroots activists and accomplished public interest attorneys. We had direct and indirect endorsements from some of the country's most well-regarded constitutional law scholars, journalists, and This, I just read to you a statement that we made to the world that basically what was supposed to be our inalienable rights were no more privileged, no more than privileges doled out at government discretion. I think it's like a 8 or 10 page submission. So a lot more was in there. What, you know, in 2010, that statement I just read to you was alluding to the same shell game that Opt-in USA denounced through its annual report a little more than 5 years later. So we weren't calling it a shell game in 2010, but we were pretty much alluding to what we ultimately came to describe as a shell game. And some of the same people who were part of making that UN submission are leaders of the Opt-in USA campaign. What I'm hoping you notice is that from 2010 to 2016, in our Opt-in USA report, we're describing, no, in the 2016 report, it's describing a pattern that was clear and that the report described as the third degree. Opt-in USA explains that the third degree is a persistent national pattern of persecution and psychological torture imposed through US legal system abuse. And the report goes on to say, the scheme of the third degree has 5 specific goals and is implemented through 7 distinct US legal system abuses. 5 specific goals implemented through 7 distinct modalities, 7 distinct ways of abusing the legal system. If you haven't looked at those 5 goals and 7 modalities, you should, because Opt-in USA is contending that if you are the target of organized US legal system abuse, which we were calling the third degree, we still call the third degree, 1 or more of those 5 goals are being served. And 1 or more of these 7 different ways of abusing the legal system is manifesting in your case. Now, Opt-in USA, you have to consider the law project. Remember, we have always been, from our inception in 2005, a think tank. So we are analyzing this phenomena of US legal system abuse. At this point, from 2005 until 2016, where we announced to the world that there's a pattern, there's a national pattern to how all of this abuse is taking place. It can be determined on objectively discernible, pursuant to objectively discernible criteria. Now, this is not just some opinion that we developed. This was after years of looking at this phenomena as it unfolds across the country. We're getting reports from individuals who claim to be enduring this organized abuse, meaning it's deliberate, it's not haphazard. There's essentially an implicit or blatant agreement to deliberately violate your right to a fair and impartial legal proceeding. So we're monitoring this. We're monitoring social science research. We're monitoring historical analysis of this type of phenomena, and looking at relevant human rights law. We're not just, in our opinion, coming up with this off the cuff. So the pronouncement that this pattern exists is influential because of the nature of the role that the Law Project serves in grassroots U.S. legal system reform. We might be, yes, we are a grassroots organization. There's no major corporate funding. This is not some government sponsored endeavor. But we have made sure that we always serve the role of this objective, an authority on the phenomena of what so many people across the country were claiming to experience, and that is deliberate violation of their rights. Because we need someone, we need an advocate in our community that takes that position, that they are objective in their analysis. They're looking at all of the perspectives. They're looking at what's happening from the standpoint, from the perspective of, of all the relevant stakeholders. Now, that it's important that at least one advocate in our group, or one element of our U.S. legal system reform community, is performing that function. Because if we're all speaking as a voice for certain special interests, there's nothing wrong with that. But it's difficult to move from supposedly, representing a certain population and then claiming to be objective and speaking for all the stakeholders. So the Law Project has been careful to try to maintain that neutrality. And so when we document that as to everyone who contends to be subjected to this persecution, sometimes to the point of psychological torture, there's a pattern to it. That's a helpful finding. That's a public service that the Law Project has provided. And here's one of the other more explosive findings of our report. According to Opt-in USA in 2016, when the goal is persecution or torture, and the instrument is U.S. legal systems, participants only appear to be part of adjudicatory processes. You only appear to be part of adjudicatory processes. There's appearance to everyone, the onlookers, that you're there, and the goal is to resolve a conflict pursuant to law and a fair and impartial administration of justice. But Opt-in USA is saying that there are actually one or more of other 5 goals that are being served. Now, by this point, the Law Project had been in existence a little more than 10 years. And we advocated, we did some advocacy, some case-focused advocacy. We, in addition to serving as a think tank, we always, maintain our objectivity, but we did speak out with regard to certain special interests, as long as you are transparent about who you represent and you are not speaking on behalf of a certain interest group while purporting to speak for all people. So we've been in existence for more than 10 years as of this debut report, and we've been addressing this problem, and along with countless other advocates and individuals across America, everyone who was contending that they were being subjected to this form of persecution. It's getting worse. It was 10 years at that point of us working to combat this organized abuse of the legal system, this deliberate violation of rights. And here we are 10 years later writing about it. And is more blatant. It is manifesting itself through national patterns, objectively discernible patterns. And one of the last points of Opt-in USA's 2016 report is that while, as of that time, it wasn't much taken seriously by mainstream America, that our country's legal system had become a pretty common instrument of persecution and torture. So we weren't, being very well believed. But those of us who were alleging to be targets of this persecution were being silenced in some very disturbing ways, some highly questionable ways. So I'm hoping you're hearing me. This is 10 years, more than 10 years of trying to contend with persecution, the misuse of our country's legal system, and it's getting worse. It's getting more blatant. It's patterns that you can detect. Opt-in USA's next report is a winter of 2017, 2018 edition. And no, our ranks of the persecuted, we weren't circling the wagons, except, perhaps within the many schools of thoughts that splintered our national community, a more cynical way of cliques, our little standalone groups. We were circling the wagons among, within these, inner groups. But as a national community, who at 2016 were being subjected to persecution and psychological torture on objectively discernible terms, we still hadn't really come together to fight this thing. This winter report that I'm talking about is titled Judicial Impunity. The subtitle is a likely, inadvertent, but deadly failure of American democracy. Now, again, these are reports. This is not op-eds. These are, analytical reports that the Law Project is publishing. And it's an assessment of the state of our country, the state of our legal system with regard to this phenomena of deliberate violation of rights. And that is being facilitated by various presiding judges. They're helping us along. This is getting serious. We use the word deadly in our subtitle. The national community may not have been circling the wagons, except again within our inner circles. But Opt-in USA was turning up the volume because this report accompanied a complaint to the UN Human Rights Council, pursuant to which I was a member and representative of class of Americans, and I'm going to read the description. A class of Americans who, as of 1990 or later, exhausted all ostensible avenues of relief before the three branches of U.S. federal government and appropriate state governments in seeking a fair and impartial redress of actual or reasonably perceived U.S. legal system abuse facilitated by unchecked judicial misconduct, and whose claims, so we were seeking, to redress this abuse, but our claims were respectively thwarted, primarily due to America's de facto policy of judicial impunity with regard to such allegations. Okay, that is just a fancy way of saying that, this persecution was going on. It was objectively discernible. We had done all we could do since 1990. This is the winter of, it's January of 2018. And we're representing that our efforts were being thwarted through a de facto policy on the part of our country to do nothing, to hold the judiciary accountable for their role in this organized abuse of the legal system. And again, this is the winter report is reaching these conclusions based on historical analysis, not just members of our organization, esteemed scholars, social science research, and at this point we're talking about the policy of our country is nothing's going to happen. That's not the coincidence. That's a de facto policy of our country. That's what we're representing to the United Nations. And by saying de facto, we're acknowledging that we're not saying that, you know, they had a big meeting, you know, in Washington D somewhere, or Washington D.C. or wherever this would happen, and they say, okay, let's make sure that if anybody alleges, you know, this third degree, that nothing's going to come of it. We're not saying it happened like that. It's just basically, you know, with the, you know, see no evil, hear no evil, you know, speak no evil, nothing happened. Since 1990, I'm describing this problem. And, you know, at this point, it's not clear whether this is a real problem or it's a perceived problem. All we know is that our research was confirming that it existed, and the fact that it was a pattern to it moved it away from being able to suggest that this was all in our imagination, because, you know, we're all, you know, it's happening across the country in basically the same way. So it's January of 2018 at that point. And you know, we're saying to the UN that this has been going on since 1990, and it's becoming more blatant as well as deadly. And what do we mean? Yes, a lot of people weren't living long enough to get relief. In that sense, it was deadly. There were people who were committing suicide, you know, and attributing it to the torture of having our rights deliberately violated on a persistent basis. People died under questionable circumstances. There were, they're out in New York. I remember specifically, a gentleman did a video, and he says, if I would to, you know, expire, you know, anytime soon under questionable circumstances, this, you know, relates to this case. And he was dead in 2 days. Yesterday, 2 or 3 days afterwards, he got hit on the head with a boulder outside of his apartment building. Okay, so yes, it was some questionable deaths. You know, this Optin USA's debut report was January 2016. My late husband, who co-founded the Law Project, was our primary financial benefactor. He was dead 5 months later under circumstances that I have contended was directly related to organized U.S. legal system abuse and constituted a wrongful death. Over and beyond that, we had most of our community that we experienced stress-related conditions and stress-related behavior. So if you had parents, for example, who were the target of this organized abuse of the system, and you were a minor or you were a teenager, then what was happening is that the direct targets were experiencing stress-related health conditions, or, for example, their children were engaged in stress-related behavior because their parents are all wrapped up in fighting this, you know, the court systems and weaponization of the legal system abuse. So you got your teenage children during their formative years don't have your attention, and they're drinking and they're acting out and they're driving too fast and they're being promiscuous. That's stress-related behavior. And we had experts to confirm that that was literally shaving as much as 20 years off of our lives. So that's what we were talking about. All of these situations were led to us characterizing this as deadly and suggesting, when you consider the intergenerational impact, our numbers were getting to the point that it would be fair to describe this as a Holocaust. Almost exactly 5 months after this report was published in my complaint, this class action was filed before the UN Human Rights Council. Almost exactly 5 months after that, the United States resigned from the UN Human Rights Council. You know, and I have never seen an explanation for that resignation. that didn't relate to problems that, disputes, disagreements that were long standing. But all of a sudden, exactly 5 months after this complaint was filed, the Human Rights Council was intolerable to the United States, and we left. Then a little less than 4 months later, the council notified me, sent me a letter of its findings, and they were astoundingly in favor of Opt-in USA constituents. Yet, that's October 2018. Yet, as of Opt-in USA's 2019 report, our campaign was grappling with the lack of constituent support. So let me back up. In January of 2018, I'm attesting to the UN that our community sought redress of U.S. legal system abuse facilitated by our judges dating back to 1990. And I represent that pretty much all of our efforts were thwarted primarily due to this de facto policy of judicial impunity. So, we're telling the United Nations that our judges, some of our judges, are in on this deliberate effort that is killing us, killing people in our community, and the United States is not doing anything about it to protect us. And they haven't since 1990. This is just my opinion, and you all can take issue with it, put it in the chat section and comment. But I think that it's a statistical improbability that pretty much all of our efforts were failing over the course of 1990 to January of 2018 because none of us were quite good enough in seeking redress. Now, some people have said that, and I just think that that's a mathematical improbability, that the problem is no one was quite doing it, was doing it well enough. In other words, I'm just not buying that among as many as, at one point, we were online quite a bit, and as many as 1 million people seem to be directly impacted. That's not our families. I'm talking about people who were in court, whatever, probate court, family court, criminal prosecution, before a professional disciplinary agency. And at one point I just had the perception that it was at least 1 million of us out there. And, the notion that none of us had quite a good enough legal argument, or, a public awareness campaign, or, a protest, or petition, or this or that. We just, it just wasn't good none of us was doing it well enough. And that, if we had only done this or that, or done it better, that many of us would have succeeded by now. Over the course of 1990 to 2018, I'm just not buying that. However, even to this day, the overwhelming majority of us who contend that we've been subjected to this organized legal system abuse are still trying to prevail without supporting Opt-in USA and acknowledging that the decks are stacked against us. Now, we have never suggested that anyone has to exclusively support Opt-in USA. Continue, yes. I mean, this is our country, ineffective or not. Our legal systems is our country, is what we have to use. But also support Opt-in USA as it contends that, our options locally are ineffective. Up until this day, the overwhelming majority of us have not done that yet, or seem unwilling to support Opt-in USA. I see it as we're essentially saying that, there's a trick to us winning, and if we just, do this right little thing here, get the trick, we can win. So there's a trick to us winning, but we don't seem to be willing to say that there's a trick to us losing. As Opt-in USA's lead strategist, I hope to inspire a lot more of our constituents to, provide us support But we're not doing that because this campaign is a numbers game. And Dr. Daniels, Alcaraz, and I are going to try to make clear that Congress and arguably our presidents since 1992 when they ratified this Iccpr, they have tried to make this a numbers game, trying to make a numbers game out of protecting Americans from persistent abuses of US government power. However, I'm going to read to you all, and I know it's a bit cumbersome to hear quotes and they're not on the screen, you're not reading, but I just want to read this and hopefully it resonates. Every citizen of the United States is entitled to the protection of the federal government and his right to be governed by and pursuant to laws enacted only by representatives elected for that purpose and in accordance with a Republican form of government. Such is the law of the land as proclaimed by the U.S. Supreme Court, citing our U.S. Constitution, Article 4, Section 6. I think it was in 1912, I believe that was. They didn't say every citizen as long as you all get enough people to the rally. Every citizen as long as your petition, meets that 100,000 threshold where they'll, send the petition to the White House for consideration. They said every citizen is entitled to be protected by the federal government from being subjected to law that wasn't duly enacted. So if this is just something that some connected attorneys, our prosecutor, our disciplinary bar attorney, and the presiding judge has concocted, that's not an elected body, but they're deciding the law of your case. And when we can't get any relief, that's not a Republican form of government, because a Republican form of government means we have representatives who are looking out for our concerns. Moving on. Opt-in USA's 2020 report is actually a retrospective on the law project and is tracking our tremendous progress since 2005, despite all these stumbling blocks I've talked about. And that progress is about, much more than what the law project has done. It was really about our close working relationships that we had developed with some of the most productive U.S. legal system reform advocates like JAM, the Judicial Accountability Movement, and LUI, Louisiana United International. In fact, as of this year, both of LUI's co-founders are on the Law Project's board of directors. Elder Carl Brown and Belinda Parker Brown is our community outreach director. Parker Brown was recently honored by Powerhouse Global Magazine as one of the world's most dynamic women leaders. So, we're saying that we can do this. I mean, there's so much strength out there in the community. And the Law Project has always acknowledged, yes, strength comes through solidarity. But you can have solidarity when many of us work separately, but we coordinate and even, consolidate when that seems necessary. The Law Project, unlike some advocates, we've never taken the position that you've got to join one group or be in this one coalition. It can really get unwieldy, unmanageable, if you have an entity that gets, too large, particularly when we're operating on a volunteer basis and we don't have major corporate funding. So we haven't discouraged people from doing it going out on their own. I mean, we do discourage reinventing the wheel. And that's a part, I just want to mention that's a part of what happens. You have people understandably thinking that, okay, this trick will work, and we'll be able to turn this legal system abuse around. For some reason, the United States has decided, no, we're not going to, it's just going to be impunity. And so people, as I mentioned, they burn out, some pass away, and then a whole new crop. The system is steadily producing these victims of this deliberate violation of rights, and a whole new crop of people come on the scene. And instead of looking at what has been done and what was accomplished and what the obstacles were and how we might be able to overcome it. That's what the Law Project does. A lot of people just say, well, nobody before us has done it right, and we're going to, and then they start over, and then they learn the same lessons that everybody else learned. And so that's how we get from 1990 to 2018. And here's this, this conference in 2021. Solidarity is still eluding our national community of U.S. legal system reform advocates. And that may be why the Trump administration felt free to address our concerns as critical, but not among our nation's most pressing concerns, as of America's January 15, 2021 report to the UN Human Rights Committee. Now, the committee is a UN treaty body. It derives its power and its jurisdiction from agreements, UN treaty, whereas the council is a UN charter body, and its authority is derived from the UN charter. So it's close names, but it's two different entities. It took me a long time to just figure that out. The UN is a big operation. Addressing the committee, the UN Human Rights Committee, for some reason less than a week before President Trump left office this year, his administration implicitly conceded on behalf of our country. This is not, they weren't speaking for their views. On behalf of our country, they conceded that organized U.S. legal system abuse, implicitly they conceded it, that organized U.S. legal system abuse is among the nation's critical and relevant human rights issues. They conceded that. They didn't try to quibble with what we said and what the UN Human Rights Council had determined. They implicitly conceded that it's a critical and relevant human rights issue, but it's just not, according to the Trump administration, among our most critical and relevant human rights issues. That's the representation that the United States has before the UN Human Rights Committee. Opt-in USA responded with its annual report on June 15, 2015. What is that? About 6 months later, exactly. And this report reminds everyone that per the UN Human Rights Council is not whether U.S. judges weaponize America's legal system with impunity against U.S. citizens. The only concern the council had was to what extent. You see, the council can only intervene in these situations when the abuse happens on a wide scale basis. So, and what does that mean when you're in a country such as America that has 300 million people? If, 1 million of us are getting the shaft and our judges are, actually engaged in conduct that's leading to premature death or worse, is that wide scale? Is that a gross human rights violation? Now, I believe, and this, put it in the chat if you disagree, I believe that Opt-in USA established for the Human Rights Council that organized U.S. legal system abuse facilitated by unchecked judicial misconduct happens on a wide scale basis. I believe we established that. Yet, but the council has yet to agree, which suggests, that the suggestion is that Opt-in USA has a numbers problem. And the Trump administration may have seized upon that and suggesting that, America has more pressing things to do because this is not a gross, human rights violation. And that's a term of art that it's a lot of factors, but it needs to affect several people. And so, you know, maybe the Trump administration was picking up on, not even the UN Human Rights Council thought we had established that this was a gross problem. And so perhaps they felt justified in saying that our country has better things to do than protect us, even though we recognize it's a bad situation. Opt-in USA's 2021 report, and you see I'm up to the current year, so I'm almost done. We denounce this approach for basically two reasons. Number one, and we got our fancy analysis, and the documents aren't too long, but this is, we cite studies, we cite law, we cite historical analysis, all of that. But, our basic argument came down to, you don't make it a number game. You don't metaphorically, conduct an airstrike on your citizens, your average citizens, over the course of like 1990 to today, 2021. When we first got started, 2016, when we first went to the UN, 2018, all this time, this U.S. legal system abuse is like a metaphorical airstrike that you're pounding the targets with. You don't do that and then say, well, we're going to measure the damage by a show of hands. We're all obliterated, and they're saying, well, can you raise your hand from the rubble? And then if it's enough of you all, we can decide that this was a pretty bad thing. And I'm not suggesting that we shouldn't raise our hand to be counted as best we can, but I think that analogy is pretty, appropriate. That once if you can imagine being in an airstrike, a lot of people are not going to have the wherewithal to be raising their hand. Number two, and this is the legal point, among competing social crises, choices must be made. You're absolutely right. You can't do everything, but you do not make choices among the privileges and immunities of U.S. citizenship. America does not have classes of citizenship, at least, to the extent that we're letting all our citizens be considered 100% human. We haven't always done that. And of course, when we move past that pretty blatant ignorance, we still have these de facto caste systems that have to be challenged pretty regularly. How about, whether women get equal pay as men, and racial discrimination, and the plight of transgender youth. And so, officially, we don't have classes of citizenship. Officially, there is no segment of Americans entitled to effective avenues of redress for their injuries, while other U.S. citizens are not. That is, unless the Biden administration agrees with the Trump administration and is going to leave undisturbed our country's January 15, 2021 declaration to the effect that, it's okay that some American citizens, we got some other things to do. So some of you all are not going to have effective avenue of redress, and that's critical, that's urgent, that's terrible, but you're not going to get it. If you allege something other than, your judges are in on fixing, outcome of your legal proceeding, then maybe you will get an effective avenue of redress. But if you show up talking about the fixes in, I got railroaded, they're against me, we got other things to do than worry about what's happening to your life and how it's being devastated, you and your family. That's the position that the United States has taken as of its 5th periodic report to the UN Human Rights Committee. And so far, the Biden administration has not responded to the Law Project's June 15, 2021 request that it renounce that declaration and proceed to comply with the Iccpr. There you go, the state of the union, the state of our legal system. We're waiting on Biden to let us know whether all Americans count or whether there are some of us who can be persecuted with the involvement of unethical judicial officers who will not be held accountable whatsoever. Now we have 5 minutes before my colleague Retta M. Daniel Alcaraz joins me, and as I indicated, we're going to talk about the Iccpr because we don't want to presume that everybody knows. What I think I'll do is go ahead and I'm going to see if I can bring Ms. Alcaraz. I think that I'm going to have a problem just bringing the two of us on the screen. So you see in all of our roundtable participants, and Dr. Daniel Alcaraz is in the corner up there on my screen. So I'm going to just keep it on speaker view. And so Dr. Daniels, why don't you feel free to go ahead and unmute your microphone, and while you go ahead and talk about those documents, I'm going to do my best to take a look at what we got in the chat room and see if anyone has responded to what I presented so far. So why don't you go ahead?
Okay, thank you very much. My name is Retta Moore Daniel Alcaraz, and I'm going to talk first, of course, about the Iccpr, which was foreign to me, although I found out that one of my former clients had appealed to the UN twice under the provisions of that division. It's really regarding the Covenant on Civil and Political Rights. It's a key international treaty, human rights treaty. It's supposed to protect and preserve basic human rights all over the world, such as the right to life, to protect and preserve basic human rights for human dignity, equality before the law, which we know doesn't exist in the United States, freedom of speech, assembly, association, religious freedom, privacy, freedom from torture, ill treatment, and arbitrary detention, which in some instances doesn't happen in the United States, gender equality, which is a big issue recently in the last 2 or 3 years, the right to a fair trial, which is a really important issue, and Zena has touched on that, the right to have a good family life and family unity, and to concentrate on the rights of minorities. That's the overview of what the Iccpr encompasses. It's a huge amount of scope, and if with the huge amount of scope, you'd get a huge amount of work, but without cooperation from the United States and the other nations around the world, it's not going to happen. That's just the bottom line. It's just not going to happen. The RUD or RUDs, they're interesting because they basically say you can be a part of the treaty, but you can reserve reservations, understandings, and declarations when you ratify the treaty, which of course is what the United States did. Consequently, there's no individual who can find redress. They can seek it, but they cannot get redress from the Iccpr. I happen to have a client who attempted that twice before I represented him. He was incarcerated in the Philippines, and he's a U.S. citizen and a great citizen. Greece participates and the U.S. participates, and I feel sure the Philippines, although it's not on the list here, participates. So in 2014, he appealed he sent out a petition to the Iccpr and said, please help me. I'm imprisoned in the Philippines and I'm being held for extradition, and the United States is not processing that. So I'm just being held in this detention center with no right to a trial or any redress. I'm just here on this army base next to a firing range. And, I need to have my civil rights recognized and protected. Well, that was all well and good. They sent him a nice letter back saying, you didn't send us the right information. And it took him 2 years to do that. And then this is the kind of stuff you need to send us. So when he got that in 2016, this is a very determined man. He communicated with them again in 2017, and he cited the Convention Against Torture and Other Cruel and Inhuman, Degrading Treatment and Punishment, the International Convention on Civil and Political Rights, Malicious Delay of Justice, Convention on the Rights of the Child and its optical protocols. And then he started into his long explanation, completed with exhibits of his detention in the Philippines until they decided they weren't going to keep him any longer. He was raising too much hell in that country about their political leaders while he was in the detention center. And he was very successful in that. Some of them have gone to prison, and some of them are awaiting prison. And then they sent him back to Greece because that's where he had come from. Well, the minute he got to Greece, they arrested him as a fugitive, which he wasn't a fugitive because he'd been detained for extradition, and they wouldn't extradite him to the United States. So they sent him back to Greece. They said, we don't want you anymore. You're too much trouble to us. So you created all this havoc with our upper political leaders. We're going to get you out of here. So they sent him to Greece. Greece arrest him the minute he steps on the tarmac. Because while he was in flight, there was an Interpol red alert issued as a fugitive from justice. And so Greece, even though he's a Greek citizen too, Greece arrests him. So then Greece puts him in jail immediately to await extradition determinations. Well, that went on for another couple of years before he actually had a Greek trial. And that area, and they decided the U.S. didn't want him, so they weren't going to keep him prisoner in a prison. They kept him in prison. But he was let out, but he was still a prisoner of Greece because they couldn't leave the country or its waters without being arrested again. And this trying to avail the system to get help.
What's the status of his situation now, Doctor?
Well, let's see now. His last trial was in probably 2017 in Greece, where he was acquitted of all the criminal charges because our country wouldn't cooperate with the criminal prosecution or the extradition. And Greece doesn't extradite its citizens to the U.S. anyway. And he is a citizen there. So they tried him on the criminal charges from Virginia. He was acquitted in Greece, but they're still pending in Virginia. So he's still a prisoner of Greece in the sense that he has to stay in the country. Okay.
Well, I have a couple of the instruments that I'm going to talk about, but I'm going to take the time in response to your account about this former client. To try to clarify some things. I indicate that the Iccpr it lists specific rights as one of the can't remember how many it is, international human rights documents that delineate our key human rights.
Right.
And what I need everyone to understand is that the for example, we have a right to fair trial, and you identified a variety of rights. Now, when your rights are violated in the context of a legal proceeding, the United States has this, I don't know if you call it fiction, but our law is set up that it may be a government agent who is violating your rights, but they are only acting under color of law. That anytime that there's someone who's cloaked with the power of U.S. government at any level, deliberately violating your rights, our law imposes this fiction. They says that they're not acting for us. You sue that individual in his personal capacity. So your rights may be being various human rights may be violated by individuals. However, it is not the United States of America that is violating your rights, according to this case, Ex parte Young. I have the citation if anybody needs it. It's a 1908 Supreme Court decision. So what I want everyone to understand is to try to distinguish between the judge or the prosecutor or the connected private attorney or your private attorney or the law enforcement officer who was, in your opinion, or the evidence suggests, was in on deliberately depriving you of a fair and impartial legal proceeding. Distinguish between those players violating your rights versus what Opt-in USA is contending.
Yes.
We are contending that the United States has violated the Iccpr by failing to provide us effective protection, effective redress from these individuals. So it's a big difference. The United States is, I don't even know if the Iccpr, I guess you could use that. If we could bring individual rights of actions, we could use the Iccpr and allege our individual rights. But what we're not saying that the United States is violating our rights. We're saying that the United States is not effectively protecting us from people who are deliberately violating our rights. So when people, and I saw in the chat, some people say, well, I contacted the UN Human Rights Council, I never heard back from them. Many people have attested to that. And we're gonna talk about why that happens. I gave some indication of it. The UN Human Rights Council can only get involved if you can establish this gross pattern. So if you come in and just talking about your case, or I've heard people say they submitted evidence of trafficking of seniors in at least 800 cases. Well, the UN Human Rights Council only has jurisdiction to consider this thing called gross violation of rights, and no individual case. And in a country of 300 million, 800 cases, 8,000 cases, who knows, 30 million, whether even 30 million would be enough. So what I think has happened, and then a lot of people are still wounded that the UN Human Rights Council was unresponsive to them. And what I've pushed is, I think that the UN Human Rights Council, whether they meant it or not, when they came in and said, the United States should be protecting your rights, if there's an illegal conspiracy to violate your rights, you should be able to go to the United States, the domestic courts, the domestic legal system, and get relief. We're not going to be a court of appeals for cases out of the courts of the United States. And if
or even a court of first impression,
or the court of first impression, if you can establish a class, basically what we see as a class action big enough then perhaps they can get involved. But basically, they're saying, don't bring your cases to us and say that you got the shaft in the United States. This is what we'll do. And this is what's so phenomenal about what they did for Opt-in USA. We will back you in saying that the United States is not giving you effective relief, avenues of relief, because we can't be guaranteed we're going to win our cases. But we will declare that when you allege that the fix was in, the United States has a de facto policy of you're not going to get anywhere. And that is a violation of the Iccpr, and we will hold them responsible for that. So you see what I'm saying? They're not taking your case, but they're joining in with us and pressuring the United States to do what it's obliged to do for us, and that is allow us to have a fair and impartial resolution here at home. We shouldn't have to go to the United Nations and say that our grandmother is being, has been kidnapped and is being held against her will as part of a bogus adult guardianship while her estate is being depleted. We should not have to take that to the United Nations, even if it's happening on a wide scale basis, again, until it gets gross and how many cases that has to be. But the United Nations will say, if you take it to our own domestic courts, you're not getting a fair and impartial resolution. You're not getting resolutions fast enough. You don't have adequate access to justice. It's unaffordable to get lawyers. The lawyers are intimidated. You can't trust it. They will even represent your best interest. So that's what they're saying. And then there's a lot of people, are saying, oh, you're going to the United Nations. We should stay within our own country. This treaty is the federal, the Iccpr is federal law. This is the law of the United States. Our Constitution indicates that any treaty that we ratify becomes the law of this land. So the UN is not going to be doing anything to the United States. It doesn't have the power. It doesn't send troops in and grab our president by the collar and say, you better, make sure Zena gets a fair day in court. It doesn't happen like that. When you see the UN involved in military initiatives, they call it peacekeeping initiatives. And that is like a coalition of member states who agree to send in, their country's military power under the UN peacekeeping banner. The United Nations does not have any armies. They don't have soldiers. They don't force any country to do anything. However, the findings, it is the most prestigious global institution of its type. You have the Organization of American States. The United States have not agreed to, that they have any jurisdiction over our country.
The United States is never going to agree.
Right. They are a member of the United Nations. Okay.
Right, but they're against the one world order, for instance.
Yeah, well, of course, and people have a right to feel that way. So here you got this treaty that you cannot
you can't enforce.
If you go to the UN Human Rights Council, unless you're prepared to do some big class action, and keep in mind, they didn't say go get a lot of people who are willing to say they got railroaded. They said go get a lot of people who have reasonably reliable evidence that they've been railroaded. Mm-hmm. Well, how do you do that? Who pulls that 10 million cases together? Our volunteer organizations. It's you see, when I say that they tried to make it a numbers game by imposing this gross, criteria, but they forget that as American citizens, our rights are not about numbers; it's about citizenship.
It's interesting that you say that because the United States is like an island.
Well, let me
in the world.
don't go into that analogy. Just let's go over a
Okay.
few more because your analogies are like gold. So hold up on that. Let's go over a couple of more
Okay.
documents. So you talked about the RUD.
Yes.
The United States adopted the Iccpr, but it said it's not self-executing. It declared it's not self-execute. Hopefully, everybody understands that means we have this treaty, but no one can go into any domestic court or before any foreign body and say, I'm here to enforce this treaty.
That's
That's what it
correct.
means, but at least in the United States, that's the interpretation of it. So you got a treaty that you can enforce according to this declaration. Then, yes, you can take a complaint to the Human Rights Council, but be prepared to bring, 30 million of your closest friends with you. Okay.
Yes,
This
and
this
he didn't have 30 million
the,
friends.
the gift that keeps on giving. Now, I want to tell you all about the optional protocol. That's where we get opt-in USA from. People think it's just we want you to opt in and support us, but we're really talking about this optional protocol. And the optional protocol is really a separate instrument. It's sort of like its own individual treaty. And the first optional protocol, with regard to the Iccpr, if you ratify it, you recognize the competence of the UN Human Rights Committee to receive and consider communications from individuals, subject to its jurisdiction. So, for example, if America has ratified the Iccpr, which it has, then if our country would ratify the first optional protocol, then we could go take our complaint to the UN Human Rights Committee, because the United States would acknowledge its competence to receive and consider our complaints. They call them communications. And our allegations that we are a victim of a violation by the United States of any rights set forth in the covenant. So, they're really contemplating us taking the United States to the UN as opposed to trying to go to the UN to get it resolved, our individual disputes, the judge and the lawyer and the prosecutor. The UN is really want to say, bring to us what you're saying that the United States is doing to violate your rights. So hopefully everybody's following that. Well, the United States they haven't ratified that optional protocol. And I think you were mentioning that, Dr. Daniel Alcaraz, that some historically authoritarian countries have ratified the first optional protocol. I'm always using the example of China. You can as an individual take communications to the Human Rights Committee and say that the Chinese government is torturing you and get a decision based on your circumstance. You don't have to account for 29.99999 other million people. Just prove that the country was violating your rights. That's a much more manageable burden, because then I only have to keep up with what happened to me and the evidence that I have to prove that, it was a violation of my rights. Well, I can do that if I was a Chinese citizen, but no American can do that. Okay. Now, the next document that I was supposed to review, and if Dr. Daniel Alcaraz, if you could take a look at our chat and see if we're getting any comments that are directly related to what we're saying. While I go over this resolution, and it's adopted by the UN General Assembly on December of 2005. So this is a month about the time that the Law Project got incorporated, and the members of the United Nations were getting together, isn't this nice, and issuing a resolution that sets out the guidelines for making sure that there's a right to a remedy and reparations for victims of gross violations of international human rights law and serious violations of international humanitarian law. Now, this is an 8-page document, and I imagine the United States was involved. I think we were, because for a minute we stepped out of the United Nations, but I think we were a member at this point. I can't remember. But, they got together and they gave us all the rights you can imagine. I mean, they ordered, they suggested they should set aside money. They defined victims to include our immediate family members. It's like, suspend the statute of limitations under certain circumstances, and whatever you do, never let those type of limiting factors, impede relief. They allow for us to get treatment. They make sure we have access to justice. I mean, everything, reparations. And this is, they talk in terms of you should get it for not only the judge and the crooked lawyer that railroaded you in the first place, but also the United States for failing to protect you from this. And you went from one court to another, one agency to another, and got nowhere. That causes harm separate from the original abuse of court. But they put in that gross violation again. They put in this ringer that we've got to, you only get this right if you and 29 million other or so of your friends can prove that you are this victim.
We do have two comments in the chat room.
Mm-hmm.
One is, please elaborate on the term of non-self-executing.
Okay.
Well, the treaty is not self-executing. You have to have, each country has to decide if they're going to join in first, and then to what extent they're going to participate. That's where the RUDs come from, and that I talked about a few minutes ago, reservations, understandings, and declarations.
Exactly.
The U.S. used, okay, we'll be a part of this, but our RUDs from the U.S. make it inapplicable unless the country itself would take on some major issue as a country,
yes,
not as the United States of America, and then go and say, okay, we want to seek some kind of redress. But it doesn't mean that they will get it, because it's up to the Human Rights Committee and the Iccpr to determine if they're going to even hear it.
Yes. Well,
so it's not something where you can file a suit like you do in a court.
Right.
And you're going to get heard, whether you win or not, something else. But you're going to get at least one hearing in that court system normally. Sometimes it doesn't happen in my experience, but generally speaking, you'll get a hearing at least one time.
Well, what happens with the Human Rights Committee is it's not a hearing. You submit everything in writing, and then they take a good little while, and they come back with determinations. The benefit of I don't want to lose this point about the self-executing. It's interpreted, that phrase is interpreted differently in America versus among European scholars and scholars in other parts of the world. But what they're saying is, if we got this treaty, and unless we enact some separate legislation, Congress enacts a legislation that gives you a cause of action premised on the language of this treaty, you can't enforce it. It cannot be enforced anywhere. Now, they did allow, as you indicate, if another country wants to bring a charge against the United States, then another country can bring a charge against the United States. Now, okay, what's the chances of that happening? Okay.
And the other chat is right on point.
Mm-hmm.
It says we need to fight for that first, meaning we need to fight for we need to fight for the optional protocol first. Yes. We need to fight for the first optional protocol so that Congress needs to ratify and the president must sign into law through legislation of bills. It would seem, well, yes, it would seem that. That's exactly the goal that you seek if you want to have change affected in government and how government functions. And so, yes, the way to do this is
The
would be
fight
to
for that.
find sponsors who have enough clout to take it to Congress, both houses, and get maybe separate bills or maybe a joint bill passed that says, okay, we want to work on we are going to implement the first option protocol.
Right, right. And then they also have a second optional protocol that we may want to consider too. But right now, and I'm going to just say this phrase, but I don't want you to start your discussion about the island yet. Just let me go through a few more things, because then we're going to give you the spotlight about the island analogy. But we're on an island. If some unscrupulous people are violating our rights under color of law, they're using the court system, they got cooperating judges, and you go to the disciplinary agencies, and you go on appeal, and you go to the U.S. Supreme Court, and you go to Congress, and you go to the prosecutor, and you go to the FBI, and you go to the Department of Justice, and the UN has determined that that's ineffective if you are there saying that the judge was biased against you. Now, we pointed out that if you go there and you have evidence that maybe the judge committed, engaged in a bribe, some garden variety criminal activity, and you have direct evidence of that, then you might get a hearing. Somebody might listen to you. But if you go in there talking about they were just against me, and there is bodies of law. We didn't make up the notion that someone can conspire to deny you a fair and impartial adjudication. That's actually in the case law. So this is not just some conspiracy theorist daydreaming. Okay, these are real causes of action. And okay, don't let me lose my point. So we're on this island, and first of all, Opt-in USA wanted the American people, not just the people who are dealing with this abuse, the American people to realize that if we allege that our country is our members of government are abusing our rights, we can't step off the shore to get any type of relief. And another point that I've tried to emphasize is that, yes, in this country, there are causes of action that address unlawful conspiracies, and even under some certain circumstances, yes, you have the judicial immunity, and a lot of people complain that you can't sue the judge, but I found it could be a strategic advantage to be able to sue the judge's co-conspirators and let the judge stay out of it. You don't have to defend against the judge's attorneys. I have been involved in litigation where they bumped the judge out, claiming he was immune. I don't think it was a fair application of the doctrine. But guess what? I was still suing his alleged co-conspirators, and I didn't have to serve the state attorney general because he was out of it. So sometimes it can be easier not to sue the judge. But I'm gonna lose my point.
Well, let me speak to that just a minute. So that there are some alternatives depending on what state you're in, and the states are also islands.
Oh, let me you're going into your analogy, and let me make this point. Okay, because before I forget, senior moment. Today is my birthday, by the way. So
happy birthday.
And I'm really up there. But what it is that we have these causes of action: unlawful conspiracy, RICO,
yes,
basic 1983, basic federal, Bivens actions, where we can go in and allege that these things have happened. But what I have tried to impress upon everyone is that the UN, the global bodies, will come to a determination that our legal system is not providing ineffective redress. Our legal system is being weaponized against its own citizens. try to get any judge to reach that conclusion as part of a conspiracy action or a RICO action or whatever you want to call it, even though these domestic due process, equal protection, um, conspiracy theories contemplate the weaponization of our legal system, our country is not accustomed, our jurisprudence is not accustomed to speaking about our country's conduct in those terms. It sounds crazy to talk about the weaponization of the US legal system in this country. But among international human rights advocates who are dealing with brutal dictators, who, and presidents that control the entire judiciary, they are comfortable with the notion that government is, that the judiciary is not independent and it's just a weapon to subdue, political rivals and unpopular dissent. They're comfortable with that. What they're not comfortable with is talking about it with regard to the United States of America. Now, that's not because they don't think that kind of thing happens, but that's just not, we're the gold standard of legal systems. And the United States has consistently taken the position that, yes, we're not perfect and there's no such thing as perfect justice, but you're not going to get a better break. You're not going to get a fairer outcome before anybody, global or not, than you're going to get in this country. And that's been the prevailing thought. So what Opt-in USA was able to establish is that over the last 2 or 3 decades, they've been tinkering with our legal system and widening subtly the gaps in the anti-enforcement mechanisms, and to the point that it's the best legal system in the world if they decide to let you have the benefit of it.
That's right.
So, and how do you do that? This is not, meet me in the alley with dark glasses on, trench coats and money. This is doing things like the U.S. Supreme Court confirming that prosecutors have unfettered discretion as to whether they prosecute a crime or not. And I was talking with Belinda Parker Brown. LUI we're looking at a case came out of Georgia recently, and now we have momentum to start establishing that these prosecutors are using this discretion to the point that they're obstructing justice. They're pretty much, in some instances, fairly characterized as accomplices after the fact. You go in there, you have this compelling evidence of someone deliberately, like my husband's case, the wrongful death suit. They won't even have a meeting when we say that we have compelling evidence that his death was reckless or intentional. We have compelling evidence, and we have groups that attest to it. You don't even get a call back. So at some point, they're covering up crimes. And that's when they weren't complicit in it from the beginning. So that's what I wanted to emphasize, that, having the international human rights community overlooking this process, when they're comfortable with looking at a nation victimizing its own citizens, and they know the signs of it, and they're not afraid to acknowledge it, and thinking that we can do it all here in the United States and get courts and judges and legislators to say that sort of thing about our own country. So, out of some sense of patriotism, let's not air our dirty laundry, on a global stage. It makes us very vulnerable. And now I'm going to shut up, and Dr. Daniel Alcaraz is going to give us her wonderful we're on an island analogy.
Yeah. Well, a lot of people think of the United States as being just one big blob. So it's one big island, and it's all intricated. So there's no differences. Now, we know as citizens that each state has its own body of law, criminal and civil, and administrative. So they're individual islands within the big island of the United States. And then you get down to the lower levels like counties and cities and so forth. The client I spoke about has been waiting 30 years to get tried. The indictments are 30 years old, and he can't get recourse. And he's gone to every agency you can think of in the United States and can't get recourse. So the option one idea is to try to get our national government to participate and provide people who are caught in this kind of situation some kind of recourse as an individual. Not, he'll never get 30 million people who are in his circumstances. It won't happen. It cannot happen. However, anyone who's been held off from prosecution for 20 years because they won't extradite him, even when someone volunteers to be extradited to the FBI, literally walks into the FBI office in Greece and says, I'm turning myself in to be extradited, they still won't transport him. That type of abuse needs some kind of redress. So when we look at the United States, we have to look at the United States as different parts. And when you get down to the county and city level, you have county and city criminal, traffic, and civil laws as well. We're unique, and that's, in terms of the world, we're pretty unique in the sense of our governmental systems. And we do have multiple systems because we got the federal, state, and local. And the locals can be broken into cities and counties. So, that's one of the reasons why there needs to be, for the United States, there needs to be a different kind of redress if you can't effectuate that redress through every avenue possible that you exhaust in the United States. And he's exhausted them. Now, in Virginia, I picked up on something you said about judges. In Virginia, we're doing something new. Judges have to be lawyers in Virginia. They must be. And they have to be lawyers in good standing to be, we don't elect our judges, to be appointed by our General Assembly, which is our legislative body. So we devised that we could go after the judges in ethics cases because they have no immunity in ethics cases. And in the ethics cases, we can say they violated the Code of Professional Conduct, which is what we call it for lawyers in Virginia, and they violated the judicial canons as well, because they're both judges and lawyers. So there's a group that have filed numerous cases now against judges in Virginia and allege that they violated the professional standards for both entities, the judicial standards and the lawyer standards. And we're doing that as individual civil suits, civil ethics complaints. The bar can't stop us because they don't have an exclusive on it under the statutes. That's why the person who commented about we need to get the legislature to act, Congress in the sense of the United States, and local legislators to act, legislatures to act in states. That's why that's so important. Now, I fully expect in our next legislative session, which would be in January, that they're going to pass a law that says citizens can't bring civil ethics complaints against lawyers or judges.
Now you're getting to the point of their determination of the ineffectiveness, because
limiting our rights.
The ability, the Iccpr compliance process obliges the United States to look at its legal system, assess with our input why it has not effectively protected us from these particular abuses and what is necessary to change them. and arrange for us to be compensated, made whole in addition to that. So what Opt-in USA is pushing, is the Biden administration, is to start working on a form of a FEMA for the courts, because this is a man-made disaster and we needed a federal emergency management association. And to because it's going to take whether it's congressional hearings or what, exploring, looking at our legal system. And you all are going to talk at the roundtable what type of changes, substantive changes you want to see in the law. and explaining why it has not been effective, what's going to be necessary for it to be effective. And in the meantime, all of us need to start to be compensated, either from the private parties that harmed us, or the United States for its failure to protect us. One thing I really let me
I
make
want to
this
bring up.
let me make this really clear,
Okay.
and then I'll be quiet, because I don't want people to miss this, even though we'll have a chance to talk about it after the panel discussion. The United States is obliged to provide effective avenues of redress because it's a party to the Iccpr. These guidelines might be contingent on it being a gross violation, but the United States still is obliged to provide us effective avenues of redress, which includes making sure that we get compensated for our injuries. So they don't get out of it. President Biden is not off the hook because they threw this word gross in different points of these treaties and in these UN documents. Our country still owes us a fair remedy. In fact, that is the standard: a fair and adequate remedy. They may argue that they're not obliged to adhere to this resolution that promises us everything. We're all going to get cars and vacations, and we're just going to get everything. The Biden administration can take a position: we don't owe you all that until you all show that this is gross. Now, if you can get the word out, this is not a numbers game. But when we are quiet, when we say Opt-in USA is fighting for enforcement of these rights, and we got five emoticon responses on Facebook, it's real hard for us to create the impression that this is a widespread problem.
Right.
And that type of resistance is happening because people are preferring to try other ways. Now, I want to talk with you, talk in response to a comment where they were talking about why doesn't the AMA stand up for the embattled doctors. And I think our panel members are going to talk about that. Then we're going to take a little break so our panel members can get organized before that discussion starts at the top of the hour. We talked about this. We talked about this at last night at a Turning Point deep dive. There is a lot of money and power and influence invested in maintaining the status quo. A lot of money, power, and influence invested in changing the status quo. And the a couple of professors, political scientists, in 2014, they conducted some social science research, and their findings was that in the United States, with the exception of well-funded unions, and they've pretty much decimated them, organizations, no matter how large, that are supposedly voices of average citizens, to have zero impact on public policy in the United States. Zero impact. This is not their opinion. This is social science research. I'm not saying that it's nobody can dispute it. I'm just saying this is what the finding is. Now that they acknowledge that doesn't mean that we never get what we want, but as average citizens. But usually we get what we want if there's some wealthy people who want it too. And what they acknowledge is that beyond the elites and the powerful unions, you have a better chance of impacting public policy in this country if you are what's called an expert advocate or a business advocate. So chambers of commerce can sway public policy. They can get Congress to do things too. Um, a bunch of scientists can get together and have persuasion. And let's say it's not even that many of them. Medical doctors. You get enough medical doctors to say that something is a problem, and you know 200 medical doctors on a letterhead um, can affect more than 20,000 average Americans who are just speaking because they are a direct victim of the problem. Don't shoot the messenger. That's what the social science research has found. And you can read it in detail. Is set out in Opt-in USA's 2017-2018 winter report. But we're not taking the time to read it, and we just keep saying let's go back. Let's have another protest, and let's get bigger, and it's about numbers. When the science is saying that our democracy is at such a compromised state that unless you have big bucks, you can't get big enough. And don't forget what we pointed out in 2016. We might be able to get some good head of steam going, but they don't just sit back and let you do this. They take your job. They write you up on a disciplinary charge. They take your children. They send you an indictment. So, if you think you're just going to sit down and just work up a head of steam and get your friends together, they'll look and they said, oh, this Dr. Daniel Alcaraz is at the head of this. How about we? And they do all kinds of things, horrendous things, you know? And a lot of times it's not even cleverly hidden. But if your adult son is facing some bogus criminal charge, and they want to pull your money that they can see that you're spending fighting the system, how about you have to go and hire a lawyer so your son won't have a chance, won't end up spending 20 years in prison based on something they found in his car that's not even characteristic of him. You see what I'm saying? So this notion that somehow might makes right, that we can just get big enough, understand the benefit of numbers. Yes, we need to get big enough so it won't look like just me and a couple of my friends are complaining about this. And numbers are important. But this notion, we don't have the benefit of major media. We saw what happened with the Black Lives Matters and after George Floyd's tragic murder. Yeah, they had major multi-billion-dollar benefactors. Black Lives Matters was not just a couple of fed up Black people who decided to do something in the basement of their of their apartment one weekend. So our reliance in the media, so much of our momentum depends on media support, major media support, exposure, and it needs to be positive. How many times have I seen legal reform advocates circulate, oh, I'm going to be on 60 Minutes, I'm going to be on Good Morning America, and they get on there and they put just enough of a sound bite for them to sound like crackpots. So what I'm suggesting is not that we don't continue to mobilize and organize. We just understand the science, the history, the empirical data that suggests what we can accomplish and what we cannot accomplish. And we continue to put pressure on the Biden administration to start this Iccpr process, compliance, start this evaluation, start this FEMA. And then we also can simultaneously get on Congress and say, also give us options outside of the United States. But we've got to stop thinking that we could just celebrity ourselves to justice. You know, they kind of want things to stay the same. And you know, again,
Well, we can look at some models.
and then in 5 minutes, we're gonna. If can you take 5 minutes, and then we'll take a break.
Yeah, we can look at some models. I'll give you one model that's very effective, the American Petroleum Institute. It is a lobbying group that has lobbying offices in every single state and, of course, in Washington, D.C. I had a brother-in-law who worked in Virginia, Georgia, and D.C. for that group. They're extremely powerful. Of course, they're funded by the oil companies, Shell and, Exxon, and those people who have tons of money to fund them. But it takes power and money to lobby any legislator, any legislature, and get something done that you want done. And if you've got the power and the money and the influence of significant legislators, people in the legislature, to push the bills through, then you can get what you want. And the American Petroleum Institute is one of the best illustrations I know of. The ABA and the Medical Association, MBA and whatever it is, ABA and MBA. Okay, they are more social than they are lobbyists. Mm. They have no enforcement powers over lawyers or doctors. They're big organizations. People like to have them on their resumes. It makes them help climb up the corporate ladder in the legal profession, the medical profession, or whatever. But they don't do any kind of discipline or anything like that. They print nice big magazines, looks great, but that's not the kind of thing that the American Petroleum Institute does. It musters the money to send the lobbyists into the legislators and talk to the legislators individually and take them out to dinner and give them wine and whatever they want to drink and that kind of stuff. That's how that legislation is accomplished on the state and the federal level. So, we can muster everything we want to muster, but we're caught in a circle, like you mentioned earlier. And someone put up on the screen in the chat that they had filed a complaint against a judge. It doesn't work because the state, in our state, it's called the Judicial Inquiry and Review Commission. They don't discipline judges. They're supposed to. They did 2 last year, 2 people out of all the judges in Virginia. Then you've got the state bar in various states. All the states have these entities. They're governmental entities. They're either good or they're bad or they're mediocre, but they are part of the government. And the first time I used a statute in Virginia to go after lawyers that had been in place for many, many years, maybe 50 years, they changed the statute the next legislative session. That's what they're going to do with the statutes we're using now. They're going to take those rights away from us because the state bar and the Virginia Supreme Court has such power that they can muster the money behind the scenes because they're not supposed to lobby. They can get lobbyists who lobby for them. They can get the key upper echelon senators and representatives to push the bills through, and they can change the legislation. And then they can preclude the remedies that you as individuals have. I fully expect them to do it again because no one thought about the fact we could sue civilly for ethics. You can't ask for money, by the way. If you ask for money, you go into judicial immunity. But if you don't ask for money, you don't go into judicial immunity. Otherwise, there'd be no reason to have a judicial inquiry and review commission or a state bar because you can't seek money from them directly. in your cases for ethics violations.